You turn into the Four Boxes Diner video channel because I tell you what's going to happen months, if not years before it's going to happen, so you can prepare. Now you can see it's true once again. Today, a major article in Slate talking about how, quote, volunteer moms, that's right, folks, volunteer moms are poring over the archives of history to prove Clarence Thomas wrong and to show that the Second Amendment is not what it says. Stay tuned. Let's talk about this and what it means for your rights when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, which is the A to Z guide of how the anti-gunners intend to take our rights away, both at the wholesale level, the retail level, dealing with the banks, dealing with all the various issues, including red flag laws in extensive detail. I laid this out for us to understand, because if we understand what the anti-gunners are trying to do at every step, we have a chance to fight back, but we got to know what they're doing. We need to know their plans. We have to reveal the secrets of their enigma machine so we can fight back and win for our rights. All right, folks, so funny story in some ways, but we're going to take it seriously because I take all threats to our rights seriously, even if it's kind of a funny, jokey, goofy concept. So today in Slate, a liberal publication, relatively respectable. They have some good writers over there. I actually like some of their work. I don't agree with most of it, but Slate's actually credible in terms of having quality writers. So they write an article today called The Volunteer Moms Poring Over Archives to Prove Clarence Thomas Wrong. Now, to sum up this article, which I'll put a link to down below, all they're really saying is they've got a bunch of volunteers who are going out there trying to find that there was massive gun control at the relevant time periods, and those constitute historical analog laws referenced by the U.S. Supreme Court in Heller and then Bruin. And thus that justifies cutting back on our civil right, our constitutional and civil right to keep and bear arms. Now, nothing's wrong with the article, but I want to talk about the effort here. The first observation I have is this. Does the anti-gun movement in America really need a bunch of volunteers? It's always interesting, by the way, when I see the word volunteer in the context of anti-gun groups, as opposed to, let's say, paid members of the NRA, right? Because anyone can be a volunteer. What does that actually mean? I'm on an email list? I volunteer to take emails from your organization. Does that make me a volunteer? One wonders. Nevertheless, it's just interesting that with the number of billionaires, the number of Ivy League institutions, the number of public health schools, including the Johns Hopkins Public Health School named after Bloomberg, literally named after the Michael Bloomberg School, that's what it's called. Given all the money from the federal government, keep in mind that the Department of Justice budget alone for 2023, I think, is like $70 billion. Not to mention all the massive multi-billion-dollar budgets of the anti-gun cities like Chicago, Los Angeles, California, New York, D.C., and so on. Given all these billions upon billions of resources in the anti-gun movement, they're bragging about having volunteer moms poring over archives in history to prove Clarence Thomas wrong, that indeed there is massive gun control everywhere. Now, obviously, this is not going to work for many reasons. The first is I can hire every person on the planet to try to go out and find, let's say, that all the founding fathers were gay. Well, good luck with that, because this doesn't appear to be true in any respect. Okay, so they can hire all the volunteers and all the people they want and do whatever they want to try to find that there is massive gun control law and a historical tradition of gun control law in America. Have at it, because they're not going to find it. You see, it's not as if people have not been studying the Second Amendment. Keep in mind that the Second Amendment and the Bill of Rights was adopted in 1791. One of the earliest major Supreme Court justices by the name of Joseph Story, who we've talked about before, who was a huge supporter of the right to keep and bear arms. He said it was the palladium of our republic, meaning the safeguard of our republic was an armed citizenry. That was Supreme Court Justice Joseph Story, who was also a major fan of freedom. So much so that you may recall from the movie Steven Spielberg called The Amistad, dealing with slaves that revolted and revolted really against their Spanish captors on a ship called Amistad. It was Supreme Court Justice Joseph Story that wrote the opinion that said that the slaves were free for various reasons, and ruled in favor of freedom of the slaves. And that was memorialized in the movie by Spielberg called Amistad. Check it out if you haven't seen it. Joseph's story, the justice that made this decision, is the same one that loves the Second Amendment. And I bring this up because he wrote one of the earliest constitutional treatises of what the Bill of Rights and the Second Amendment. So even at the time of the founding, people were writing about what the Bill of Rights meant and all of this stuff. So it's not as if, and this is only 250 years ago, it's not as if we're asking people to go back in time when it comes to historical analogs or history to the Middle Ages and try to study like the 1450 Spanish Inquisition or whatever it is, right? We're literally only going back a couple hundred years, pretty good records all the way around. Keep in mind, people like Adams and Jefferson and Washington, they have volumes and volumes and volumes of letters and books and stories and information that they themselves wrote. So there's not like a lack of information about the founding period of 1791 in this period. I mean, they've literally done Broadway musicals, 1776, about this time period. So it's not exactly as if this is some period that you're not going to be able to find anything about. Of course, what's going on here is that the volunteers are trying to find some support for why there's gun control is allowed under the Second Amendment. But that's the first observation. None of this is necessary because you have these multi-billion-dollar organizations that are already funding anti-government work, not to mention the CDC, Center for Disease Control, which claims that gun violence, which is a euphemism, or I should say a political propaganda term by the anti-gunners, that this is a pandemic or this is an epidemic. I think CDC should be studying some other things other than gun violence to keep us safe, but we'll set that aside. Beyond that, keep in mind that it's kind of amusing that these billionaires have all this money, and yet apparently they are having free, unpaid pro bono volunteer researchers trying to find this out. This seems rather silly. Keep in mind that in 2008, now, in addition to the fact that we've been studying American history and the Bill of Rights for literally over 250 years, I mean, Harvard's had a law school for over 200 years. There's law schools in America for 200 years. People have been studying this stuff and thinking about this stuff forever. So it's not exactly as if there's going to uncover new and unusual stuff, in somebody's attic. That is highly unusual at this point in American history. I think a lot of this has been done. But beyond this, keep in mind that, but let's carry on. So what exactly are they trying to prove? As you know, the U.S. Supreme Court says that once a gun control law in modern-day America implicates the text of the Second Amendment, which is the right of the people to keep and bear arms, where the word keep means to possess, the word bear means to carry in public for self-defense, among other reasons, all lawful purposes. Well, guess what? Once that's implicated, the burden shifts to the government to come forth to show there's some sort of long-standing historical tradition of regulation of the gun that's consistent with the Second Amendment. The classic example I like to use is to really what is the gold standard is, at the time of our founding, you could not use a firearm to commit murder, rape, or robbery. You could not do that. So if you are challenging on Second Amendment grounds a law today that says you cannot use a firearm to commit rape, robbery, or murder today in the 21st century, indeed, you would be able to trace the lineage of those longstanding restrictions on the right to keep and bear arms going back from the founding all the way up to today, because the right to use a firearm to commit, malum in se crimes such as murder, rape, and robbery was never viewed as a right. That was a crime, and people always understood that to be the case. That is what the Supreme Court is saying when they say if there's a longstanding restriction on your ability in some way to use a firearm, in that instance to commit crimes, well, yeah, then the text of the Second Amendment, the text of the Second Amendment could be implicated, but the history says that you don't have a right to keep and bear arms to do that. That's what they're trying to look at. Now, of course, what's going on here is these volunteers are obviously trying to find any and all examples of gun control to try to justify and uphold modern-day gun control laws. Now, I don't think they're going to work. I don't think it's going to work for many reasons, but I think one of the things that stands out most to me is they're looking in the wrong time period. And here's how it all starts out. If you look at this article, it starts off with how exciting it is, right? Quote, the archives that this person, Birch, encountered were clean, dark, and mostly empty, with large tables upon which the archivist laid a series of fragile law books from previous centuries. Woo! I feel like, this is like the start of some sort of movie about the inner secrets of the Vatican or something, right? Anyway, we'll continue on. Examining the delicate pages, Birch was surprised by what she found. Santa Anna prohibited the concealed carry of weapons, including guns, in 1892. 1892, late 19th century. Too late. No, but let's carry on. The article goes on to say that Birch was surprised by what she found. Santa Anna prohibited the concealed carry of weapons, including guns, in 1892, while neighboring Anaheim followed suit in 1893. You get the point? Couple things. First of all, we know that historically, states could either allow or could ban concealed carry as long as they allowed open carry, or you could ban open carry if you allow concealed carry, but you have to allow carriage. So the fact that they found prohibitions on the carrying of weapons concealed doesn't speak to whether or not could you carry them open at that time in California. So that's the first thing that the law that they found means nothing in and of itself. Second of all, it's also the wrong time period. Because as we know, the U.S. Supreme Court has repeatedly said that the relevant time period for determining whether or not there's a restriction on an aspect of the Bill of Rights, historically wise, such as the Second Amendment, you have to look at the time of the founding, 1791. And the reason why you have to do this makes sense, because the text of the Second Amendment was written by people, it was ratified by people, and then it was understood by people based on the history of those people. Think of it this way. If you and I enter into a contract today, and 30 years from now, someone's trying to understand what that contract means, they go back to today's world and say, well, what did Mark mean when he entered into the contract with you at that time? What did the words mean at the time in 2023? And what was their intent? What was going on that caused Mark and them to enter into that contract? You don't try to figure out what something means in 2050 when you're trying to understand what the 2023 legal document means. So the Second Amendment of the Bill of Rights and the Constitution is a legal document created by we the people, the American people. It is a legal document. So if you want to understand what the legal document means, you look to the text and then you try to define and understand what the text meant at the time it was adopted. And then to the extent you need to look at history, you look at the history at the time of the founding to see what the people that adopted, that wrote it, that discussed it, that ratified it, that embraced it, what were they talking about? It doesn't matter what someone thinks in 1895 about a 1791 legal document any more than it matters what somebody might think about my contract, 50 years from now after I'm long dead, that I entered into today. It doesn't tell us anything at all, keep in mind, about what the people who adopted it meant. So the fact is, now, by the way, I've written about this in the Harvard Journal of Law and Public Policy. I'll put another link to it down below that says that late 19th century historical analogs can only do one thing. And here's the tricky little thing. Be very careful about this. You've got to understand this. It is true that late 19th century gun control law or gun history, gun right history in the late 19th century, it is true that it might be relevant. It's maybe relevant. However, be very careful. It can be relevant to the extent that it serves as a confirmation, as an affirmation, as a confirmatory analytic of the 1791 understanding of the document. It cannot contradict, undercut, or reduce the scope of the rights from the 1791 Second Amendment or the Bill of Rights. It cannot do that. You see what I just said? Late 19th century post-Civil War Reconstruction era gun control laws or gun discussions could potentially be relevant, but they're only relevant to the extent it confirms and reaffirms the 1791 understanding. If that late 19th century laws contradict or undercut the 1791 understanding, it is not relevant and not to be considered. It's only relevant if it confirms the right. It's not relevant if it undercuts the right. That's the only way the late 19th century historical laws involving guns can possibly be relevant. Now, several months ago, I told you that this is where the anti-gunners were going to go. They were going to go to the late 19th century, which is why I wrote that article, which I'll put a link to down below in the Harvard Journal of Law and Public Policy, debunking this entirely, 7 Ways to Sunday, which I completely did. But I'm going to give you something right here and right now that I think you're going to really love. I actually did a video on this about 6 months ago saying this is very important for you people in the Second Amendment community to be aware of. It is the 2020 decision by the United States Supreme Court in a case called Espinoza versus Montana. This involved whether or not governments such as Montana or the federal government can ban monies going to sectarian or religious-oriented schools, or whether or not doing that basically violates the First Amendment's right to religious freedom, non-establishment religion, sort of all of that gestalt of religious freedoms in the First Amendment. And here's what's so important and favorable. This is very good news. This is very powerful precedent. I want you to tell all your friends if you're involved in Second Amendment litigation about what I'm about to say involving this Espinoza case, which I did a whole video on this several months ago, but I'm going to reiterate it right here and right now because this is going to come up in the Rahimi case where the anti-gunners are using the late 19th century gun control laws to try to cut back on our rights. And as you can see right here in this article from Slate about the Moms Demand Action volunteers, they're laser focused on the late 19th century, which is too late and totally irrelevant because it's contradicting the 1791 understanding. To undercut it, it is not allowed. Now, don't just take my word for it. I want you to take the word of someone that might know a little bit about this. That is Chief Justice John Roberts in the Espinoza case. Now, what does Chief John Roberts, why is this opinion so powerful in favor of the Second Amendment, even though it involves the First Amendment? Because the First Amendment and the Second Amendment are all part of the Bill of Rights, so they're interpreted very similarly in terms of what they meant. Now, in the Espinoza case, there were 30, hear me out, 30 states that had banned the use of government money to go to sectarian schools in what time period? The late 19th century. So you have 30 state laws in the late 19th century that banned the use of money to go to the sectarian schools. And what did the Supreme Court say about that late 19th century history? Did it consider it? Oh, it considered it and rejected it. 30 state historical analogs were rejected as being irrelevant to cutting back on the scope of the First Amendment. Let me read what Justice John Roberts said on behalf of the U.S. Supreme Court. Quote, "The government argues that a tradition against state support for religious schools arose in the second half of the 19th century, bing, 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 the second half of the 19th century, as more than 30 states, including Montana, adopted no aid provisions. Such a development, of course, cannot by itself establish an early American tradition. Justice Sotomayor, who's on the other side, of course, Justice Sotomayor questions our reliance on aid provided during the same era by the Freedmen's Bureau, but we see no inconsistency in recognizing that such evidence, listen carefully, folks, but we see no inconsistency in recognizing that such evidence may reinforce an early practice, but cannot create a new one. Chief Justice John Roberts, the Supreme Court in 2020 in the Espinoza case says that the 30 state laws from the late 19th century touching on the First Amendment cannot create a restriction on the First Amendment rights. It could, in theory, affirm or confirm such traditions if it existed in 1791, which of course did not exist here, but it cannot contradict. And then, by the way, and speaking of the anti-gunners that want to use Catholic restrictions on guns and Catholics, tell me if you think this sounds relevant. From the same Espinoza case, John Roberts writes, quote, "In addition, many of the no-aid provisions, late 19th century no-aid provisions, many of the no-aid provisions belong to a more checkered tradition shared by the Blaine Amendment of the 1870s, after the Civil War, too late. Shared with the Blaine Amendment of the 1870s, that proposal, which Congress narrowly passed, would have added to the federal constitution a provision similar to the state no-aid provisions prohibiting states from aiding sectarian schools. However, it was an open secret that sectarian was a code for Catholic. The Blaine Amendments were born of bigotry and arose at a time of pervasive hostility to the Catholic Church and to Catholics in general. Many of its state counterparts have similarly shameful pedigrees." And to conclude, tell me if you think this is relevant to the anti-gunners trying to use the late 19th century post-Civil War gun control history to take away our rights. To conclude, Chief Justice John Roberts in the Supreme Court wrote, 2020 in Espinoza, the following, quote, "The no-aid provisions of the 19th century hardly evidence a tradition that should inform our understanding of the First Amendment's free exercise clause, period, close quote." You see what just happened there in Espinoza? 30 state laws, not Wild West territories, not some town somewhere. 30 state laws were used by the government to try to cut back on the scope of the First Amendment. And the Supreme Court said late 19th century laws, even if there are 30 states that adopted them, cannot cut back on the First Amendment right. In that case, free speech, free religion, free exercise of religion and clause, and so on and so on. Again, by analogy, you cannot use the late 19th century gun control laws against Americans to cut back on our 1791 rights. In addition to the fact that most of them were adopted in racism, trying to prevent the freed African-American slaves from getting guns, set aside the bigotry associated with the reason that all those laws existed. Beyond that, it's just too late in time. It doesn't speak to what the 1791 understanding of the Second Amendment meant. It's just too late in time because, remember, the last founding father dies in 1836 with James Madison, and everything after that is, again, no longer the generation that wrote, adopted, and ratified the Second Amendment. So anyway, it's very exciting, I'm sure, for some volunteers to run out there and learn about gun control laws. Maybe they should watch this channel, The Four Boxes Diner. They'd learn more about that than probably what they're doing there. But I doubt the volunteers for Moms Demand Action will be watching this channel and learning from it, although I think they would benefit greatly if they did so. All right, folks, hope you learned a little bit something here today at Four Boxes Diner. If you haven't subscribed to me on Twitter, at Four Boxes Diner, check it out. You should do that. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.